Practitioner Series. We took a month off last month because of the summit, but now we're back and we look forward to bringing you many presentations over the course of the next fiscal year that are going to cover advanced topics and that allow advanced practitioners to get together and share their experiences together. So what we're going to be talking about today is we have Megan Connor and Helen Eisner from OGE who are going to be discussing the 2014 Nominee Ethics Agreement Guide and also LA-14-05. We're very pleased to have them with us here today. Before we get into that, though, I do have a few announcements. The first one is just a reminder that our next fundamental series is going to be at 2 o'clock on November 13th. That's a Thursday. And we're going to be discussing particular matters. And on November 20th, we're going to have our next advanced practitioner, and that's going to be at noon. Also, a quick program reminder, the end of November, your 1353 reports are due. So if you have a lot of those, it'd be a good idea to get started on those now. And also, this is just a reminder in case you have any folks who are not able to make it today, recordings of this broadcast and other broadcasts that we've done in the past are all available on the Google Plus page and also on the YouTube page. And finally, just a reminder that we have a whole bevy of products available in the IEG store on the Max community page, where you can find job aids, model language, all sorts of useful things to help you with your program. So go ahead and check that out when you get a minute and join us in our collaborative efforts to make everything better. And so with that, I'm going to turn it over to Megan Connor. Megan, could you tell us a little bit about yourself real quick?
Sure. Hi, everybody. I've been with OGE since 2003, originally as a program reviewer, then as a desk officer, and now I'm a program analyst in the presidential nominations branch, working basically full-time on the review of nominee financial disclosure reports.
Great, thanks. So you're going to be talking about the new Ethics Agreement Guide. Could you provide for our listeners just a little bit of history on the development of the guide?
Sure. By way of background, OGE first provided guidance and a model ethics agreement to agency reviewers back in March of 2001. And since then, we've had the benefit of working closely with agency reviewers to develop ethics agreement language addressing a variety of circumstances. And the result is an ethics agreement guide that represents the joint product of OGE and the agencies. This ethics agreement guide, which we first issued in 2008, February of 2008, and have now reissued in September of 2014, reflects updates and new language based on the ethics community's experience during the nominee process. You can find the guide on our website in the financial disclosure section under Public Financial Disclosure, Helpful Resources. In addition to reviewing the sample language and the commentary that is designed to enhance the quality of PAS nominee ethics agreements, we really encourage you to read the introductory section for a philosophical discussion, if you will, of the considerations that are relevant to the process of drafting ethics agreements.
That's actually a really good section. I do recommend that everybody check that out. So let's assume that I'm an agency reviewer. Why should I use this guide as an agency reviewer?
Well, there's a lot of reasons, not the least of which is we found that the use of the sample language in the guide has made the certification process for PAS nominees considerably more efficient. The sample language has also established consistency among the ethics agreements of PAS nominees across the executive branch. But beyond that, the guide focuses primarily on sample language. But as I mentioned a minute ago, there are a number of considerations that we think are relevant to the process of drafting ethics agreements for PAS nominees. And using the guide can help keep those at the forefront of your thinking during the nominee process. The key consideration is that the ethics agreement is a joint product of the agency, OGE, and the Office of the Counsel to the President, along with input from the PAS nominee. And this shared responsibility, it's going to require ongoing coordination from the earliest practicable stages. And in addition, keep in mind that OGE's approval of the language of an ethics agreement is a precondition for certification of the nominee's financial disclosure report, and use of the sample language can facilitate that approval.
So if agencies are using language that's not approved, then OGE is not going to certify a report, right?
Exactly.
Okay.
Exactly. Also, the ethics agreement it's not just an add-on to the financial disclosure report. The Nominee's Ethics Agreement is a statement of relevant commitments, and it describes the course of action that the PAS nominee is going to undertake to achieve compliance with specific legal authorities. So there are other considerations that we discuss in the guide. For one, the agreement needs to be factually accurate, addressing each nominee's unique circumstances. So the sample language in the guide serves only as a starting point for an individualized ethics agreement. Know that we will work with you to develop language when unique situations come up. Additionally, the ethics agreement communicates commitments, not mere aspirations. For this reason, you're going to sometimes need assurances in advance that PAS nominees will be able to actually honor stated commitments. So don't put anything in the ethics agreement unless you are sure that the PAS nominee can actually do it. The language of the ethics agreement, it needs to be consistent, concise, and precise, which is another reason that the sample language in the guide is helpful. It helps the reviewers eliminate inadvertent variations of language, which is very important because readers might mistakenly attribute meaning to variations. And consistent with that directive to be concise, remember that the ethics agreement, it's not a comprehensive counseling document. So while it should address every relevant commitment in sufficient detail to be clear about the specific actions that the nominee will undertake, at the same time, it should only provide necessary information. When a PAS official signs an ethics agreement, they signal their commitment to ethical leadership. Their signatures also offer assurances that they are aware of the measures needed to achieve compliance with applicable ethics requirements. So remember that the ethics agreement is an agreement between the PAS nominee, the agency, and OGE. And in addition, the Senate relies on the commitments reflected in the ethics agreement when making the decision to confirm a PAS nominee. So for this reason, the agency and the nominee may not rescind a commitment in an ethics agreement, such as an agreement to divest an asset, without first obtaining OGE's approval.
So if they've already got an ethics agreement that's sort of been set in stone and they want to make changes to it, they can't just do that on the fly. They have to talk to us first.
Correct.
Okay. So I have another question for you. So could you run through, what's the language that's found in a basic ethics agreement?
Okay, sure. Let's turn to there's a sample ethics agreement found at 1.0.0 in the ethics agreement guide. And if we take a look at the first two paragraphs, all ethics agreements for a PAS nominee are going to contain those two basic paragraphs. That first one in the sample, the introductory paragraph, which you can also find separately in the guide at 1.1.0. And the second one here, the basic 18 USC 208 conflict of interest recusal, which is also found in the guide at 2.1.0. So those first two are going to be in every single ethics agreement that we have. We can also take a look at the last paragraph in the sample. The ethics agreements of PAS who will be appointed to full-time positions will also contain this language regarding public posting of the ethics agreement on our website, which is also found in the guide at 1.2.0. But note that this language is only for PAS that are going to full-time positions, and it's not applicable to a special government employee who's expected to serve 60 days or less in a calendar year, or to a career foreign service officer who is being nominated to a position as an ambassador. And additionally, though it's not shown in this sample, the paragraph that incorporates the terms of the ethics pledge will be included in any ethics agreement of PAS nominees required to sign the pledge, and you can find that language in Appendix A. Like the posting language, the ethics pledge language is not applicable to special government employees or to career foreign service officers who are being nominated to ambassador positions.
So what happens if a nominee is required to divest an asset or will be using an exemption for a holding?
Okay. You can see some of this also in the sample that we were looking at, but if the PAS nominee is required to divest an asset, the ethics agreement is going to include the paragraph regarding certificates of divestitures, or CDs, which can be found in the guide at 3.1.0. And this paragraph is important. It alerts the PAS nominees of the option to request a CD and lets them know that the CD must be obtained prior to divestiture. And that's really important for them to understand. This paragraph also alerts the PAS nominees that they must commit unconditionally to divest, whether or not we ultimately issue a CD. And as we've explained in the past, an ethics agreement may not make the divestiture of prohibited or problematic holdings contingent upon receiving a CD. As far as the exemption, if the PAS nominee is going to rely on a de minimis exemption for a holding, the appropriate de minimis exemption paragraph will also be included in the ethics agreement. The updated guide includes sample language at 4.1.0, which you can see there, which addresses reliance on the exemption under 5 CFR 264202, which is for certain de minimis financial interests and securities. And also the sample language in 4.1.1, which addresses the exemption for de minimis interest in sector mutual funds under 5 CFR 2640-201B.
So what are what are some of the other specific changes in this new version of the guide that reviewers should be aware of that we should highlight today?
Well, one change that you're going to find throughout the 2014 version of the guide is the addition of the knowledge element, which you can see incorporated into most of the paragraphs of that sample ethics agreement at 1.0.0. OGE traditionally considered the knowledge element to be implied in ethics agreements, but based on feedback from ethics officials and from nominees, we were persuaded to include language expressly addressing knowledge in the guide. However, when reading ethics agreements, you should not misconstrue any omission of language addressing the knowledge element as signaling that the nominee either has waived the knowledge element or has committed to recuse even when the PAS nominee lacks knowledge of a conflict of interest. In such cases, the knowledge element is understood to remain applicable. You know, as far as some of the specific new language we've added, I'm going to run through the language and the reasoning behind it for four sections. So if we go to Chapter 3, divestitures, which we talked about a little bit, and if we look at 3.2.4.
Give me just a second
Sure.
to get there.
Okay, so there we have 3.2.4. You'll see that we have added a paragraph for an interim 208 recusal for an investment when an investment fund and a carried interest in the fund are being divested. And in this sample, the carried interest is tied to the future profits of the fund. And this paragraph is designed to ensure that there is no confusion on the part of the PAS nominee that if the agency is requiring divestiture of the fund, the carried interest must also be divested. And along those lines, if we look at 3.4.0, and this is concurrent with the recent issuance of Legal Advisory 14-05, Financial Disclosure Requirements for Pooled Investment Funds, which Helen is going to talk about next. The paragraph regarding divestiture due to an inability to disclose assets of a non-accepted investment fund has been revised to address the requirement for divestiture due to an inability to disclose assets of a non-accepted investment fund that is the subject of a confidentiality agreement. So we added that into the end there. This revised paragraph describes a situation in which a nominee has access to information about the underlying holdings of two investment funds, but is unable to disclose that information as a result of having entered into a confidentiality agreement prior to being considered for a possible nomination to a PIS position. Note that this language does not apply to a PAS nominee for a special government employee position in which the PAS nominee is expected to serve for no more than 60 days in a calendar year. And then moving on to Chapter 9, family farms and family business.
Give me just a second to get there.
Sure.
Here we go.
While you're getting there, family farms and family businesses, they will often implicate the ban on outside earned income that was established in 1989 with Executive Order 12674, Section 102, and in 1990 amended by Executive Order 12731, and which says that a PAS nominee for a full-time federal position will not be able to continue receiving a salary from an outside entity. For the purposes of this ban, however, earned income is not limited to salaries. And a potential issue involving earned income may arise when a PAS nominee provides services that are a material factor in the production of income for a family farm or for a family business. So paragraphs 9.1.0 and 9.1.1 now include the phrase, I will not provide material services to the production of income. And this phrase provides an interpretation of earned income consistent with OGE regs found at 5 CFR 2636.303b4. And now if we turn to Chapter 10 on spouses, you can see that the phrase for as long as my spouse continues to work for has been added to sample paragraphs for a spouse's employment when the spouse does not have any equity interest in the employing company. And this phrase makes it clear that the recusal is to the spouse's current employer, and the need to recuse will cease if the spouse is no longer employed by the entity. And finally, if we look at Chapter 12, miscellaneous provisions, the updated guide now has 2 paragraphs addressing agreements with publishers, which you can find at 12.2.0 and 12.2.1. Although the ability or willingness standard applies to a publisher's payment of royalties under the terms of a publishing contract with a nominee, we believe that it's unlikely that a nominee would participate in any particular matter that would affect the publisher's ability or willingness to fulfill its obligation under the contract. So for this reason, OGE has included the recusal for particular matters involving specific parties where the publisher is a party or represents a party under 5 CFR 2635.502. So those are the 4 that I'm going to highlight right now. But in addition to these changes, we've also added language or revised language related to promissory notes, bonuses, capital accounts, trustee positions, a spouse's business, and several other sections. So please make sure that you use the new version of the guide, which again is on our website, and it's available in both Word and PDF versions.
You can also find a link to it on the Max page that you signed up for this distance learning event on. So if you click on that link, it will download the most updated PDF version of the guide for you. So real quick question, what if I can't find language in the guide that addresses my particular nominee's situation if I'm an agency reviewer?
Sure. The Ethics Agreement Guide contains about 100 sample paragraphs that we think should cover most of the interest that you encounter when reviewing a nominee report. However, we understand that you may have unique situations that are not specifically addressed, and your OGE reviewer will work with you to tailor language from the guide to meet your specific situation, whatever it might be.
Well, thank you very much for your time today, Megan. We know that you guys are very busy over there in the presidential nominations branch, and we appreciate the insights that you brought. And we look forward to having you on here again.
Great. Well, thank you.
So next up, we have OGE's own Helen Eisner, who's going to be discussing LA-14-05, which deals with pooled investment funds. And we're very excited to have her on today to discuss this important legal advisory because it's changed things just a little bit. So Helen, could you tell us just a little bit about yourself before we get started?
Sure, and thank you, Ryan, and good afternoon, everyone. As Ryan said, my name is Helen Eisner, and I'm an assistant counsel in the Ethics Law and Policy branch here at OGE. And I joined OGE back in the spring, so I'm happy to be here today to discuss our hot off the presses legal advisory, financial disclosure requirements for pooled investment funds, which is LA 1405. So what I'd like to do here today is really hone in on the type of situation we're addressing in the legal advisory, where we've come from in our prior legal advisories, and where we are today. So just a kind of basic framework, what type of financial arrangements does the legal advisory address? So the new legal advisory addresses financial disclosure requirements for PAS filers. Now, many pooled investment funds, like hedge funds, will qualify as accepted investment funds. And as we explain in our regulations, 5 CFR 2634.310C2, filers are not required to report underlying assets for such funds on their OGE 278 form. So the universe of assets addressed in this legal advisory is limited to pooled investment funds that do not reach EIF. Now, many filers are going to be able to break out and report the underlying holdings of non-EIF funds. So for those non-EIF funds where filers can break out the holdings, we're going to be able to conduct our review based on that information. Yet there are other circumstances where a filer will not be able to break out and report those holdings. And there are really two situations that I want to lay out.
So what are those situations?
Well, first, it's because the fund does not provide that information to investors. And the second situation is when the fund provides that information to investors, but the filer cannot disclose it because of a confidentiality agreement. So let's look back at our 2008 advisory, which was Deogram 08022, where we addressed these types of non-EIF funds where holdings could not be broken out. In 2008, what we did is we lumped together the two categories that I just discussed.
So for our listeners out there, just to remind us what was in that diagram, what were the two categories the 2008 advisory lumped together?
Yeah, and thanks, Ryan. It's really important to understand these two different categories. So again, it's where investors are not provided information about underlying holdings, or second, where investors have knowledge of the underlying holdings but cannot disclose them because of a confidentiality agreement. Now, in 2008, without distinguishing between those two categories, we decided to require divestiture in most cases involving both types of non-EIF funds. Now, as a quick reminder, and this is important, just to backtrack a little bit, if you can reach EIF, this discussion is moot. So we're not talking about the type of pooled investment funds where you can reach EIF, and this is guidance that we emphasize in 08022 and in our new advisory 1405.
So just to reiterate that, if it is an accepted investment fund, then we're not talking about anything in 1405.
That's exactly right.
Okay.
So what we're really talking about in 1405 is pooled investment funds that cannot reach EIF. So in our new advisory, 1405, we explain that based on our experience, the distinction between when investors are not provided information and when the filer has knowledge but cannot disclose that information is meaningful. And the point that I really want to emphasize is what's important here is knowledge. Knowledge is a critical element of 18 U.S.C. 208. And the legislative history of the Ethics in Government Act supports this, stating that the purpose of the disclosure of holdings, liabilities, and transactions is to identify potential conflicts of interest or situations that might present the appearance of a conflict of interest. So in 1405, our new advisory, we decided that the reporting and divestiture questions for PAS filers and the assessment of the potential and appearance of conflicts of interest should turn on knowledge.
Again, because that's a critical element in 18 U.S.C. Section 208, right?
That's exactly right.
Okay.
And this is really kind of important as far as our thinking for this new advisory, understanding the situation when a filer has knowledge of the underlying assets versus the situation where the filer just isn't provided that information. They don't have knowledge of what the underlying assets of the fund are. So kind of recognizing that was our approach and really thinking about the knowledge situations, let's look at the two types of scenarios that I laid out for non-EIF pooled investment funds and what's changed in our new legal advisory. So first, thinking about the confidentiality agreement scenario. So for a PAS filer who has access to information about underlying holdings, but just can't disclose that information because of a confidentiality agreement, the guidance from our prior legal advisory 08022 remains the same.
And is that because the filer has knowledge?
That's exactly right. The filer does have knowledge. He just can't. The filer just can't disclose that information. So that's really the key distinction as far as the 208 analysis is concerned, and what we're going to require filers to report. So in that situation, and again, that's the situation where the filer has access to information but just can't disclose it, we're going to generally require divestiture. And, like Ryan said, it's because of the knowledge distinction. The PAS nominee, he has this information, can't disclose it, and as a result, the public is deprived of information that the filer has about the potential for conflicts of interest. Now, thinking about the second scenario, where the fund manager just does not provide that information to investors, this is what has really changed from 1405, and this is what we really want to focus on, how to treat that type of PAS filer who just can't provide the information about the underlying holdings because he doesn't have access to it. So if the nominee has reported all information available to him, the public can then fully assess the potential for conflicts. So in that case, we're generally not going to require divestiture if certain procedures are followed. And the point here is really that the filer can access that information, the fund manager retains control of the information, and the filer doesn't have the opportunity to self-blind. So in that case, there will be no mandatory divestiture. This serves the purposes of the Ethics in Government Act and doesn't unnecessarily burden filers with reporting requirements that, where the information really wouldn't pose a conflict.
So let's assume that I'm an agency reviewer. How will this work in terms of the reporting procedures? How are those different now?
Sure. So this is really what's changed here. And, what we're going to do, and according to the legal advisory, is PAS filers who have assets in non-EIF pooled investment funds should really work with OGE to determine how to satisfy the reporting requirements. And OGE is going to require documentation, which we deem to be administratively necessary to demonstrate both a lack of knowledge of underlying assets and the inability to access information about the holdings. So generally, what we're going to require is the filer to submit a letter to OGE from a representative of the pooled investment fund. And this is usually going to be someone like a trustee, custodian, fund manager, etc. And the letter will first confirm that the filer's spouse, and the filer's dependent children are not able to control or direct the investments made by the fund. And second, the letter should confirm that the filer's spouse, and dependent children are not entitled to receive information about the underlying assets of the fund. Now, as far as OGE Form 278 is concerned, filers should include both the name of the financial arrangement and a notation indicating that underlying assets are not readily ascertainable.
So here's a question for you, though. So if I'm a filer, what if I have like some partial information? Like, let's say that I'm in a non-EIF pooled investment fund that gives me some of the holdings.
Yeah, I mean, that's a really good question, because there may be some filers who can access some, but not all information about the fund's holdings. For example, the fund manager might provide investors with a list of top 10 holdings. So to the extent known, the PAS filer must disclose those holdings in the financial disclosure report. And also, this is important, if the filer gains information about the underlying holdings during the reporting period, the filer must report this information in later reports. Now, also, in some unusual cases, the filer is going to have to identify information contained in any publicly available reports that also identify holdings. So that's really a good summary of the new legal advisory, and I'm sure that some questions might arise.
So where should folks go for questions, Helen?
Sure, definitely direct any questions towards your OGE desk officer, and I'm sure they'd be happy to answer them or direct them towards the right source. So thank you so much for having me here today.
Well, thank you so much for joining us, Helen, and for giving us some more insight and information about the underlying reasons why we changed our guidance just a little bit in LA 14-05. And we hope to have you on again.
Great.
For all of our listeners out there, just a reminder that next month we're going to be doing our fundamentals series on November 13th at 2:00 in the afternoon. And we're going to be doing another advanced practitioner at noon on November 20th. Also, for your colleagues who are not able to listen today because for whatever reason, this session and all of our previous sessions are recorded on the YouTube channel and also on Google+. And finally, check out the IAG store for a whole bunch of useful products and collaborative community things that are going on. So thank you very much. I'm Ryan Segrist, and we will see you next month.